Yes.
My lords, my ladies, let me begin, my lord, by just confirming your reading of, unsurprisingly, of Infrastructure Services Luxembourg. The paragraph reference that is relevant is paragraph 102. If it would be of use to my lady, your lordships, for me to make that available, we can have that added to the authorities bundle.
Well, I'm familiar with it, but yes, maybe it should be.
I'm grateful. I made the suggestion before lunch, my lords, my lady, that a submission was made to you yesterday that was inconsistent with a submission made by my learned friend before the learned judge as to the relevance of material post-dating the conclusion of the treaty under Article 32. I feel I should make good on that submission, and so I'll spend a few moments doing so. Because before Mr Justice Foxton, my learned friend submitted in terms that material post-dating the conclusion of the treaty would not be relevant. And we see that in the High Court transcripts, which are in the bundle. And the first reference I'm going to give you is to the supplemental bundle, tab 1, page 13. It's day 1 of our hearing, and the page references precisely to the manuscript are pages 38 and 39 of the transcript. And you'll see in the middle of page 38 an exchange between the learned judge and my learned friend, in which the learned judge was asking, amongst other things, whether supplementary material would include material that post-dated the treaty, what the breadth of Article 32 was. And in response to that inquiry, my learned friend had offered to prepare a note on this point overnight, after the first day and before the second day. And you see that referred to day 1, pages 62, which you'll find at page 29 of the transcript. So this is page 19 of the bundle, pages 62 and 63 of the transcript. Where an exchange led to the offer to prepare a note, and a note was prepared. And if we go to day 2, we see discussion of it. So this is supplemental bundle, tab 2, page 38. Where we see on pages 1, 2, and 3 of the transcript this note that had been prepared overnight being discussed. And we see my learned friend state at lines 11 to 20 on page 1. As you'll see from our note, there are, as I mentioned yesterday, various cases saying that you can take into account previous awards under Article 32. That is most likely to be by means of just general supplementary means, because it's an inclusive interpretation. The issue we are focusing on yesterday was more the one closely linked to the circumstances of the conclusion of the treaty, what was known by the parties as of 2007. So here the submission was that previous cases may be relevant under Article 32, as they may inform what was known by the parties at the time that the treaty was concluded in 2007. No suggestion was being made that anything post-dating that point in time was relevant. And then my learned friend goes on at line 21 of page 2 to reference an article by Shirlow and Weibull that he had cited in his overnight note and then circulated to the learned judge. And this is an article entitled Article 32 and Precedent in Investor-State Arbitration.
Mr. Particides, why don't you, it's maybe a spoiler, but why don't you point to the moment when a concession or something of that kind is made, and then we can look at the context.
Very well, I shall do so. The drum roll will end, my members of the court. It appears on page 2, lines 20 and 23, where reference is made to the views of Professor Alexander Orekalashvili, cited in that Shirlow and Weibull article. And my learned friend then put it thus, and this you will see that Mr. Orekalashvili in his scholarly work had made the obvious temporal point that awards after the conclusion of the treaty are not going to help.
This is in terms of being
Relevant.
under Article 32 of the
Indeed.
Vienna Convention.
Indeed. Simply in the context of what Article 32 allows you to take into account as a supplemental means of interpretation. And it was that submission that led the learned judge at line 24 of page 2 then to try and understand the chronology of the NAFTA cases that were being presented to him. And you see on page 3, him draw attention to when the NAFTA was signed, and we see in the judgment his reference to when the negotiations of the NAFTA ended. And you see on page 3, my learned friend stated that he had not gone
Sorry,
through...
you don't mean the NAFTA, you mean chorus.
apologies, the chorus. I misspoke. I'm grateful. And you see on page 3 at line 13, my learned friend saying he had not gone through a trawl of what other sort of pre-2007 awards could help on this point. And we submit that that opportunity has arisen before this court, and all you have that predates the chorus is Methanex. You heard my submissions on the timing of Bailey.
Focus here is on arbitral awards. As I understood it, the submission was being made yesterday. The submissions yesterday also relied on, if you like, the position said to be very long-standing of the United States, which is a slightly different point, as in an arbitral award might evidence that, but it's a different point.
Indeed, my lady, and I mean, in some ways, the view of an arbitral tribunal, expert or otherwise, and I'm thinking of the language of Lord Hamblin in JTI Polska referring to expert views, might be less significant than the position taken by one of the signatory parties. But the submissions that you've been presented with are submissions in cases that do not predate, so far as I'm aware, Methanex, other than the Methanex case. And they are the views of one party to the chorus FTA, again falling foul of Lord Hamblin's consideration of the kinds of materials that showed common intent that are relevant under Article 32. One way or the other, there is very little left under Article 32 for you to take into account. And with that submission, I was intending to move to the diplomatic note, which does not raise questions of Article 32, but rather Article 31.3, and the applications that are before you, which must be determined, we submit, by reference to the principles in Madam Marshall, which I was going to turn to next.
So as I understand it, you very much rely on what Lord Hamblin said in Polska. We were taken yesterday to some writings of the International Law Commission that rather suggested a more expansive approach.
Indeed, my lady, we do rely on Lord Hamblin, and I would also, again, reiterate that what you were taken to yesterday, and there was one reference in one line, in one paragraph of one conclusion to post-dating information, that was not consistent with the submission that was made to the learned judge, that he accepted, and that led to the decision
Yes,
that is
but
agreed.
I'm also interested in the position of one party point, to which your response is Lord Hamblin's focus
Indeed.
on common intent, because I think that point as well, if I recall correctly, is picked up in the International Law Commission work.
Indeed, and we would rely on Lord Hamblin's judgment on that.
It would be remarkable if one party's submissions in an arbitration where it was seeking to prefer its interests could by themselves affect the interpretation of the treaty. That would be most extraordinary bootstraps position.
In whatever context, contractual and certainly treaty as well, we submit. Ladder Marshall we could take briefly or at length. Let me try and take it relatively briefly and focus on the critical date doctrine which you received submissions on yesterday. But so far as Ladder Marshall is concerned, our submission, my lords, my ladies, that remains at the heart of the inquiry on the admissibility question that is before you. So far as the residual discretion is concerned under the CPR, we submit that it is not in line with the overriding objective to allow, and by doing so potentially encourage, self-interested statements from litigating states following the first instance decision that could have been intervened earlier, which takes us to the Ladder Marshall first limb test. With reasonable diligence, could this have been presented to the trial judge? Because if the answer to that is yes, then there is no overriding justice in disregarding that limb. And as I said earlier, my lord, you asked that question directly yesterday, and we do not think that you got an answer. The question was, could it have been obtained for use at the trial with reasonable diligence? And the truth is that there has been no submission, nor any evidence to suggest otherwise. To the contrary, the appellant has admitted in the evidence in support of its application that it did not take any steps until the learned judge's judgment. And the reference to that is Charlotte Mallory Witness Statement number 1, paragraph 8. I'll give you the reference to it. It's the applications bundle, tab 11, page 96, where that acknowledgement appears. And that acknowledgement appears even though the appellant was put on notice that its position that the requirements of Article 11.1.1 were jurisdictional in nature, that they conditioned the consent to arbitrate, was something that the respondent had taken issue with as early as August 2023. That's almost a year before trial. And that was in Elliott's request for dismissal of the appellant's challenge without a hearing, which was filed on the 11th of August 2023. And you'll find that in the application bundle at tab 16, page 117, 118 of Opus.
Don't we have to be a little bit more analytical, though, about what we're talking about with Ladder Marshall? Because the way that this document is being presented, as I understand it, is as a quote subsequent agreement quote. So it's been put in as a subsequent agreement. Could evidence of that subsequent agreement have been put in at first instance? The strict answer to that is plainly no, because that subsequent agreement didn't exist at first instance. Now, I think you've got to explain how you reinterpret the test so as to say that it could have been put in. You have to say that the test doesn't just apply to the document or to the, you've got to say that the agreement could have been made. That the test applies where to say that you can't put in evidence of an agreement if that agreement could have been made sooner. And I think that's a very significant rewording of the Ladden-Marshall test.
My Lord, I'm grateful, and I agree that that would be the formulation, but let me refer you to...
So you agree that the formulation is they should have made the agreement sooner?
Indeed, that is the true question, and described as the true question in my learned friend's skeleton, paragraph 38, so applications bundle 1, tab 1, page 16, where my learned friend described as the true question whether this could have been obtained, this agreement or this practice, I think it's being presented as an agreement, earlier than trial.
But it seems to me that just isn't the Ladden-Marshall test. The Ladden-Marshall isn't addressed to, the test isn't addressed to whether parties should have taken steps to reach agreements sooner. It's all about the admissibility of evidence. Now, if I can see that you might be able to say this subsequent agreement shouldn't be admitted for various reasons, but it seems to me, as far as evidence of the subsequent agreement is concerned, if the subsequent agreement is relevant or admissible, there's no problem about the evidence of that subsequent agreement because it didn't exist at the time. So the real question is a subsequent agreement admissible?
And whether that subsequent agreement could have been obtained pre-trial.
What? No, I don't understand that to be an admissibility question. I mean, if under the Vienna Convention a subsequent agreement is admissible, then I'm not sure what basis we would have for not looking at it on interpretation by virtue of Ladden-Marshall. You may be right that there is a different principle that prevents us looking at it. But how can we exclude on a well-known principle evidence of something which didn't exist at the time of the first instance hearing?
Well, as your Lordship said yesterday, subsequent to what is the question? And we'll come to the critical date theory. But...
I'll just flag up that I'm not sure I agree with anything that my Lord has said in the last 2 minutes, and this may be a very fundamental point, but there's a great deal of learning on Ladden-Marshall. I think Mr. Wordsworth accepted yesterday. It isn't a sufficient answer to a Ladden-Marshall objection to say, well, look at the date of the document. But anyway, why don't you argue the point about the critical date and then come back to Ladden-Marshall?
I will, but let me say perhaps by way of ending that I don't think it's an either-or. 31.3 says what it says about the potential relevance of subsequent agreement. That does not address the question of when evidence is admissible on appeal. And that is the question that is before this court, and that requires you to apply the Ladden-Marshall test.
I can quite see that if the parties had produced a document which purported to evidence an agreement they had made 5 years ago, you could say, well, it wouldn't be an answer to say, well, you've only just created the document, because that could have been done sooner. But the point is that's evidencing an agreement from 5 years ago. But in terms of a subsequent agreement, that subsequent agreement has only just been made. So it seems to me on Ladden-Marshall principles, as far as that test is concerned, that limb of the test, it couldn't have been obtained before because the agreement hadn't been made.
But therein is the question, isn't it? therein is the question. Why is it that one would abandon Ladder Marshall on the basis that an election was made for the agreement to be made only on appeal? Why can't you apply both cumulatively, as the Singapore Court of Appeal did, as we shall see, in Sanam? It applied Ladder Marshall and it applied the critical date doctrine. It thought both were relevant. But here the question is, because the presupposition, my lord, in your question is that the agreement could not have been made earlier. And that, no?
Entirely accept the agreement could have been made earlier.
Oh, okay.
Plainly,
Apologies.
it could have been made at any time, including prior to the hearing in front of Mr Justice Foxton. Accept that.
Very well. Well, then it seems to us if that is accepted, then it's not apparent why the first limb in the test in Ladder Marshall would not apply. If it could have been made earlier, then why isn't that relevant to admissibility?
Because well, I think we're going around in circles. I think the point is because we're concerned with admissibility.
Of evidence.
Yes. Not with when parties make agreements. Usually a subsequent agreement isn't going to be relevant, but it's submitted to us that it is.
Yes, and that might take us to the critical date doctrine, but we would say that is cumulative to the first limb. In any event, my lord, you have our position on that, and I will take direction that I should move to the critical date.
No, it's not a direction, it's a suggestion.
Suggestion. Why is that relevant? Why is the critical date doctrine relevant here? Where do we place it within the framework? And we place it within the framework of the second limb of Ladder Marshall. The first limb we've just discussed. The second limb is that there needs to be a showing that it will have an important impact on the result of the case. And if as a matter of international law, one should not be having regard to it because it falls foul of the critical date doctrine, ergo, it cannot be said to have an important impact on the outcome of the case. And I say that, my lords, my lady, recognising that I don't think that the case is being made against us, that the diplomatic note is in some way binding upon you. There is a mechanism under our treaty, it's in chapter 22, for joint interpretations formally to be made by the parties, taking account of public consultations with stakeholders, that arbitral tribunals should take account of. That's in Article 1122. That is a mechanism that is created within the treaty. If it will be helpful to go to those provisions before I turn to Sanam.
I think they're
I will.
cross-referred to by the judge, aren't they, or you did
Yeah.
before? Just give us the reference again.
Indeed, let me give you the references. So it's chapter 22 of our treaty. And you'll find that at page 475 of the core bundle. And I'd invite you to, in particular, look at 22.2.3d, that gives the Joint Committee the power to issue interpretations of the provisions of this agreement.
So the Joint Committee is a standing committee, as I was.
It is a committee that would meet once a year or that can be convened by the parties whenever they wish. There's nothing to have stopped, for example, Korea and the US government to have convened the Joint Committee at any stage in the set-aside application before the trial, which was about a year before the application set-aside was, for the Joint Committee to be convened and to issue its interpretation. And if I might just give you the reference of Article 22.2.6, which reads, recognising the importance of transparency and openness, the parties affirm their respective practices of considering the views of members of the public in order to draw on a broad range of perspectives in the implementation of this agreement. That is a process
Sorry, just give the reference again to that.
Absolutely.
47.
So it's
22.
22.26
Oh, thank you.
on page 476 of the full bundle.
Thank you very much.
Now that is a focus on transparency and consultation that was circumvented by way of this embassy note. And if one, and I'll give you another reference, if one looks to article in our chapter 11, 1122, so this is 1122 on governing law, 1122.3 on page 281, a decision of the Joint Committee declaring its interpretation shall be binding on a tribunal, and any decision or award issued by a tribunal must be consistent with that decision. Now, of course, we would make the submission that that doesn't evade the critical date doctrine, which would still apply. You can't move the goalposts once the game has started. But it seems to us relevant in recognizing the non-binding nature of that which has been procured, that it was not through the formal mechanism set out by the treaty that would have involved the kind of consultation that did not take place. And so the focus really is not on whether it is binding, it obviously isn't, but whether it should be taken into account. And in determining whether it should or should not be taken into account, the critical date doctrine, we submit respectfully, unsurprisingly, is relevant, because otherwise it would be all too easy for a respondent state to be a judge in its own cause by working to procure the kind of intervention that would, quote, smooth the goalposts. And that is precisely what a number of courts and tribunals have considered. I'm going to focus on the Sanam case, and then I'm going to give you references to a couple of arbitral awards which effectively sound for the same proposition. But in the interest of time, I won't take you to all of them. This is not...
What's the most authoritative statement of the critical date doctrine?
My lord, it came originally from the Minkers and Ekrehos case, which related to rocks and islets in the Channel Islands, the 1950s, and it was referred to by Sir Gerald Fitzmaurice in his submissions on behalf of the British government, successfully arguing that those rocks and islets belonged to the UK government, not to France, and there was a debate between the parties as to whether and when a critical date should apply, because of both parties' reliance on state conduct and whether they could rely on state conduct above and beyond a certain point in history. It was then recorded in Oppenheim, which you also have in your bundle. It's at tab 75, as a statement of international law, if you want, as it has a statement of Sir Gerald Fitzmaurice's speech in the Minkers and Ekrehos case. It's on page 5287. You'll see a description of, under the heading of critical date, the doctrine.
Right.
And it has been relied on not only by the Singapore Court of Appeal in Sanam, but a number of arbitral tribunals over the years, and I'm going to give you, once we've gone through Sanam, I'm going to give you a couple of references to those awards.
Okay.
You'll see the speech of Sir Gerald Fitzmaurice there, a cogent description of the doctrine. Now, the application of it to questions of treaty interpretation and in the context of an investment treaty dispute are clearly enunciated in Sanam as a recent expression of the doctrine.
Yes, right. Speaking for myself, I've read section or paragraph 273 of this. Do we go next to Sanam?
We can, my lord. I think that would be helpful. Well, let's turn to Sanam. It's at Authority 54, which I believe should be in your volume 2. My learned friend referred you to this yesterday, so I don't propose to spend too long describing the background to this judgment. The Singapore Court of Appeal was considering an appeal to a successful set-aside of a treaty award on grounds of jurisdiction in a dispute that had arisen under a VIT between the People's Republic of China and Laos. And the tribunal had held that the treaty was applicable to the territory of Macau, as Macau was part of the PRC, and thus that it had jurisdiction over a claim brought by an investor based in Macau. Laos brought the set-aside in Singapore, seat of the arbitration, and at first instance the court in Singapore disagreed with the tribunal, and it did so on the basis of a first exchange of diplomatic notes that were generated at the same time that the set-aside application had been launched. And so the first round of notes was before the trial court on the set-aside. And it accepted the statement in those notes that the treaty did not extend to Macau, and thus found that the tribunal lacked territorial jurisdiction, and so set aside the award at first instance. Leave to appeal was given, and the judgment that you have here is the appeal court's overturning of the trial court set-aside. And the appeal court had before it a second exchange, as my learned friend explained, of diplomatic notes that postdated the first instance trial. That second exchange of diplomatic notes, however, did no more than confirm the authenticity of the first exchange of notes. The first exchange of notes had been issued by the PRC's embassy in Laos. A question had arisen as to whether that was an authentic document. The second exchange simply elevated it to come from the Ministry of Foreign Affairs of the People's Republic of China. So in the event, both exchanges of notes verbal sought to confirm that the investment treaty did not extend to Macau, but the Singapore Court of Appeal took a different view and disregarded them, and in doing so invoked the critical date doctrine. Let's pick up the judgment at paragraphs 64 and 65. This is on page 4322 of the bundle, and this is where the Singapore Court of Appeal describes the doctrine. And if we turn to 67, we draw attention to the critical date that is relied on by Sanam, which is the date on which the dispute had crystallized. Actually, before the acceptance of the offer to arbitrate, the request for arbitration, it was when the dispute itself crystallized, was taken as the critical date by Sanam. And if we turn to paragraph 69, we see the Singapore Court of Appeal find that the doctrine remained relevant in this case. But it found that this did not mean that any evidence after the critical date is automatically inadmissible. It drew certain distinctions. But special care would have to be taken in assessing the weight or relevance of such evidence. Let's turn to paragraph 103 and 104. 103 is interesting, my lords, my lady, because it shows the Singapore Court of Appeal.
Sorry, just before we go there, I can't really see much debate about the applicability of the critical date doctrine.
I don't think it was contested that it would apply, but I'll need to check that, my lady.
Okay, just because it is being said against you that maybe this isn't the right doctrine.
Yes, I heard a slightly more nuanced submission yesterday, which is maybe it should be replaced by some reference to a duty of good faith. And I don't know whether that was made in the context of an alternative to Ladd and Marshall or an alternative to critical date.
I think the reason I'm asking the question is that I suppose my follow-up is, in order for the critical date doctrine to be relevant here on this question of treaty interpretation, do you not need to say that it's one of the techniques of interpretation, if you like, that should be used in interpreting the treaty? Because we've seen, for example, you took us to it, there's even a specific provision in the treaty, which, as you say, wasn't used, for a subsequent binding agreement. You then said that must be subject to the critical date doctrine. Well, to which the response might be, why? It wouldn't be, unless the application of that doctrine was a relevant part of the legal approach to take to treaty interpretation.
What I can say by way of response is that we've seen arbitral tribunals, in addition to the Singapore Court of Appeal, adopt precisely that approach, which is to consider that it is relevant.
In interpreting a treaty?
In taking account of whether something is a subsequent agreement or practice under 31.3 that should be taken into account, which is what 31.3 refers to in interpreting a treaty. I'm going to show you a couple of, dare I say it, NAFTA decisions that refer to that. I think in this context it might be said that they are relevant. I'm not asking for an interpretation precisely of the words of 1116 or 1116 of the NAFTA. I'm looking at the way in which NAFTA tribunals have applied this concept, this doctrine, to generally Article 3.1.3 of the Vienna Convention.
What we can see is that the Oppenheim textbook extract quoting Sir Gerald Fitzmaurice's speech and the Piotrowski extract in paragraph 65 of Sanam, which the Singapore Court of Appeal took to be correct, seem to me quite similar.
Indeed, ma'am.
Yes. All right, next
Now,
stop.
the debate before the Singapore Court of Appeal was not whether you applied the doctrine, but whether distinction should be made between statements that were merely confirmatory of pre-critical date conduct or not. That was at the heart of the debate and the heart of the decision of the Singapore Court of Appeal. But before we get there, if I could just focus on the terms of paragraph 103, because here we have the Singapore Court of Appeal considering the criteria in Ladd and Marshall, and also recognizing that where the substantive dispute engages questions of public international law, as is the case here, the court must consider the question of admissibility and weight within the framework of any other applicable principles of international law, such as the critical date doctrine. This is an interesting statement of the interaction between the Ladd and Marshall test and the critical date doctrine in the context of both admissibility and weight of evidence of the interpretation of the treaty. And we get to the nub of the judgment. At paragraph 106 to 108, my learned friend took you to these. And we see here the final sentence of paragraph 106 at the top of page 4341, that if the post-critical date evidence contradicts established pre-existing position, it should not be admitted. And at the other end of the spectrum, as they put it, the bottom of that same page, paragraph 108, at the other end of the spectrum, if the post-critical date evidence merely confirms the position which has been established by the pre-critical date evidence, such evidence could be relevant and may be considered. And then in the middle of the spectrum, later on in that same paragraph at the top of page 4342, the difficulty arises where the pre-critical date evidence is inconclusive. In our judgment, it is possible to admit post-critical date evidence in such a situation, but we consider that special attention should then be given to the weight that should be attached to such evidence. And in Sanam, my lords, my lady, the Court of Appeal ultimately considered that the notes did not confirm, in the circumstances of that case, a pre-existing position regarding whether the BIT extended to Macau. And so it chose to disregard them. And if we turn to paragraph 116, you see it rejecting the 2014 notes as evidence of a subsequent agreement or subsequent practice under Article 31(3)A or B of the VCLT. And if we turn, most interestingly, in our submission to subparagraph E of that paragraph 116, which you find on 4347, you see that in the circumstances, while it may well be open to the PRC allow us to enter into an express agreement today to modify the treaty in question to accord with their presently stated intentions, we do not consider this can take retroactive effect and adversely affect a third party which has already brought proceedings, which are found on the facts of that case to be in substance what the Lao government is contending for. And reflecting in this reasoning is the juridical reality that these treaties create rights for third parties. And having regard to new positions following a critical date would subject those investors, those third parties with already acquired rights, to immense procedural unfairness. But that's where the Singapore Court of Appeal drew the dividing line. We submit that that has compelling force, although we recognise that this court may not need to draw the line at exactly the same place. If the mischief to be guarded against is unfairness to third parties who have already acquired rights that have been adjudicated, including at first instance, and who had no involvement in the production of the diplomatic notes, then we submit, my lords, my lady, that the line can and should be drawn so that even if the pre-critical date position may be inconclusive, statements that involve a new position, a position that has not previously been expressed and that are difficult to reconcile with the text of the treaty, should also fall foul of the doctrine. And so
I say it's particularly invidious where, in terms, the notes are designed, make reference to and are designed to contradict a first instance decision.
Indeed, my lord. And I'm going to come to study the note in some detail with you now to show you what parts are absolutely novel and directed at the first instance decision, and those parts that could be said to simply confirm prior practice, which leads us back to the paradox I referred to at the very outset. Well, if that's the case, then what does it add? They need the novelty, as I'll show, which is why this is invidious. Perhaps just before I turn to focus on the diplomatic note, let me offer a few references to other cases that approach the critical date doctrine in a similar way. My lords and my lady, I'll give you the references if I may, if you'd like me to take you to these cases, but I'm conscious of time and I would like to allow some time for my learned friend to reply. I'll just give you the references.
Give us the references and say what court or what judge or tribunal decided it.
The first is one of the first NAFTA cases, so it goes back a long way. It's the Pope and Talbot versus Canada case. It's at Authorities Bundle tab 4, and in that case the NAFTA Free Trade Commission, which is the equivalent of the joint committee that we have in our chapter 22, after an award on liability and before an award on damages, offered an interpretation of what the minimum standard of treatment meant that was something that would have been relevant to the tribunal before it had rendered its decision on liability. And in that case, the tribunal, Lord de Verde was presiding, I'll have to be reminded who the other two arbitrators were, considered that they were not entitled to take account of that, even though it had been issued under the Free Trade Commission, the formal mechanism under the treaty, because I use the phrase broadly, it would amount to changing the goalposts. There's one other case I'll refer to you. There are others that we refer to in our skeleton, but there's one other that is recent. It is the case of Adiko versus Croatia. It's Authorities Bundle, tab 24, page 2600. And the relevant paragraph I'd refer you to is paragraph 290 of that award. And I'll find you the names of of the arbitral tribunal in that case. Paragraph 290 refers to what it regards as the temporal issue created by reliance on the conduct in that case that the respondent state sought to rely on.
Which tab, sorry?
It's tab 24 of the authorities bundle, my lord. The tribunal members in Pope and Talbot were Lord de Verde, Messrs Greenberg and Bellman, and in Adico presiding Jean Kalicki and Milos Olek and Guido Tawiyu. I give you the references, but I think in the time remaining I'll focus on the way in which our diplomatic note here introduces novelties that would create exactly the kind of mischief that both tribunals and courts have sought to guard against. Let's turn to it. It's in the applications bundle, tab 4, page 42. And I'm going to take this, my lords, my lady, page by page in order to help dissect that which is new from that which is confirmatory. Page 1, we see in the last paragraph, the bottom paragraph in that page, the US government offering an interpretation of Article 11.1.1, which replicates, almost verbatim, the appellant's position in its Section 67 application before the learned judge at first instance. No reference to prior practice in relation to the interpretation of the Korea US Free Trade Agreement is offered in support of that statement. Page 2, we see in the last paragraph of that page an interpretation of Article 11.17 of Chapter 11, which again replicates the appellant's position in its Section 67 application precisely, addressing language that the learned judge had found to mean something different. And you see no reference on page 2 to any prior practice or positions, because this position in relation to 11.17 of the chorus has never before been expressed before this diplomatic note. It is then, my lords, my lady, that we come to page 3. And here the US government tells us that its interpretation of the Korea-US Free Trade Agreement is consistent with its long-standing interpretation of, and it uses the word similar, wording in the NAFTA. And it refers in footnote 2 to various submissions it has made in prior NAFTA cases. This is the page that my learned friend spent some time on. So this is the pre-existing practice that it is referring to, prior practice taken under a different treaty, the NAFTA. But there is novelty here too, my lords, my lady, and you will have seen it, because again the US has never before taken the position that the meaning of the particular provisions of the chorus that pertain to the question before this court, that includes Article 11.16 and 11.17, is the same as the equivalent positions in the NAFTA. That position, that there is the same interpretation whether you think it's reasonable or not, is not a position that has ever been expressed before in relation to Article 1116 and 1117. And it certainly, we would submit, is not an obvious proposition because the language between the two treaties, as we have seen, is different. And that brings us to the final page of the note, which in some ways is the most revealing. So we come to page 4, because here in the first full paragraph of the page, the US states that the distinctions that exist between Articles 1116 and 17 of the NAFTA on the one hand, and Articles 1116 and 1117 of the chorus on the other, do not support a divergent meaning. Now, this is addressing the learned judge's judgment. But again, this is new. That is a position that has never been stated before by the US government, and that's why you see no references to prior practice. Not only new, my lords, my lady, but a bare assertion that doesn't grapple with the ways in which the different language led the judge to consider that they did not lend themselves to the same interpretation. Now, I've been through those divergences. They pertain to the references in 1116 to extending the consent to submit to arbitration to investment authorizations and investment agreements. That is different between the NAFTA and the chorus. And so the question becomes, can the US government's prior interpretation of the NAFTA be superimposed onto the chorus FTA despite these differences? And the learned judge focused on those differences. And whatever you think of his reasoning, the US position here to say that despite those differences, the interpretation should be the same is utterly new. That is a novelty. And that falls foul of the critical date doctrine, which returns us to the paradox. If all this did was refer the court to a position previously submitted, it would serve no purpose and would not be admissible under Ladd & Marshall. And if it does more than that, it falls foul of the critical date doctrine. If it does more than that, it should not be admitted in any event, because it ought to have been admitted before the learned judge. Novelty, my lords and my lady, bare and bold novelty, which is precisely the mischief that we submit should ensure that it is not admitted. My lords, my lady, if I can help you more on the critical date doctrine, Sanam, or how it applies to this note, I'd be happy to. If not, I'll move to the final segment of my intended remarks.
How long have you got to go? I'm not asking that as a hostile question. I just want to know whether we should take a 5-minute break now.
If we take a 5-minute break now, my lord, it may be that I may even have less time to go. So.
You can collect your thoughts. Very well.
says it's a wants to seriously have a trial, medical evidence. Judge says we've got to switch to report up. They go and get some appeal between the trial and appeal. They procure a new medical report. In other words, the equivalent of the agreement could be what exists at the time of the trial. The Court of Appeal says this. Once again, these statements could plainly have been obtained in good time for the hearing. So the point is that something exists, but could have happened falls within the ambit of Ladd and Marshall, according to the Court of Appeal.
Here's my thing, I think. And I thought it was quite useful.
He then went into the details.
He said,
Yeah, you sure that? So if you want to, we've got copies, which is, it's paragraph. The point is not argued, but the court assumes something which did not exist.
the agreement?
So it wasn't an agreement, it's new medical reports. The court assumes new medical reports which did not exist will create facts of the appeal while within the ambit of Ladd and Marshall. And we've got copies of that. And so it may not be. It's our full jury. It may not be going to have Falk and it may have it's your friend and mine. It's Scott Baker, the judge. Did not exist. Whether they should switch off life support machine.
Okay, I'll use it.
And it's just the court doesn't rule on it, it just assumes that newly procured material, like an agreement, falls in the ambit of that time. You've got to give a copy of it to us.
Yeah.
You don't have to, just. No, you don't have to tell him about it. You can leave it. Your judgment.
Court rise.
My lords, my lady, you'll be happy to hear you won't be hearing very much more from me, just a few final remarks. My lord, in relation to the question that you asked about the relevant question or the relevance of Ladd and Marshall in the context of subsequent agreement that did not exist before, we've done a little bit of digging, and there is one judgment of the Court of Appeal that we draw to your attention that may be of help. It is the case of the Fixlers versus Manchester University NHS Foundation. Lord Justice Barker, Lady Justice Carr, Lady Justice Elizabeth Lang. This pertained to a challenge by the family of someone who was on life support to a decision to turn off medical assistance. And between a first instance decision that went against them and the Court of Appeal hearing, there was the obtaining of further medical evidence that did not exist before the trial judge. And so the question arose how to address that previously non-existent evidence in the context of Ladd and Marshall. And the court's consideration of that question, in particular at paragraph 55, we submit will be of assistance to this court as well in the decision to apply Ladd and Marshall, because the relevant question was whether that previously non-existent medical evidence could have been obtained earlier. It may or may not assist you on the point we were discussing, but we wanted to bring that to your attention.
Could evidence of the medical condition have been obtained earlier?
Could the tests that had not previously been obtained have been obtained earlier?
Yes. But that was all evidencing the medical condition, presumably.
Yes.
Well, if it's one paragraph 55, would you like to read it out if we haven't got it?
Indeed. I would also refuse the parent's application for permission to file the other documents. The statements from the air ambulance service and the Israeli medical institutions fill a gap in the evidence about which the judge remarked. For my part, it is unsurprising that the parents' representatives have been unable to identify an air ambulance service willing to transfer Alta to Israel, or that there are several clinics in Israel with the highly specialized facilities required to care for the child, where an English court decide that it is in her best interest to move to Israel. Once again, however, these statements could plainly have been obtained a good time before the hearing. In any event, in the light of the judge's observation at an earlier paragraph of the first instance decision, paragraph 102, it cannot be said that this evidence would probably have had an important impact on the outcome of the appeal.
Thank you.
My lords, my lady, the last segment of my intended submissions on the admissibility question pertain to what weight, if any, in any event, should be applied to the diplomatic note. As you heard me say at the very outset, we see this as a self-interested document. Treaties are two-way streets. The US government's evolved view of treaties, once as swords, now more as shields, is well known and publicly available. I don't propose to take the court's time leading you through the evidence of that evolving public position that we have referred to in our supplemental appeal skeleton. I'm simply going to give you the references to it. It's paragraphs 40 and 41 of our supplemental appeal skeleton. That's in the applications bundle, tab 2, pages 30 and 31. and invite the court to have regard to them if it so wishes. My lords, my lady, concludes my submissions.
Thank you very much. Mr. Petrofilos?
No, my lord, thank you.
Mr. Wordsworth?
Thank you very much. Apologies for the delay. My lords, my lady, can I ask you to start by turning back to the judgment of Mr Justice Foxton and ask you to go to paragraph 47 of the judgment, and that's at tab 6, page 90 of the core bundle. Now, I would like to start by saying a few words about Article 11.17, because my learned friend virtually ignored this provision, despite the great emphasis that I placed on it yesterday. I placed that emphasis on it yesterday because this concerns the state's consent to arbitrate. Now, you read, of course, at paragraph 47, each party consents to the submission of a claim to arbitration under this section in accordance with this agreement. Now, you saw at paragraph 48 how Mr Justice Foxton interpreted those words under this agreement. And to refresh your mind, he is reading at Roman 2 there, 48, the words in accordance with this agreement can naturally be read as a reference to consent to arbitrate only in accordance with the mechanisms for arbitration provided for in the treaty, and when the treaty procedural preconditions for commencing arbitration are satisfied. 11.16, he then says, is replete with such conditions. And then you see over leaf again his final analysis at little Roman 3. When therefore Article 11.17 provides for consent to the submission of a claim to arbitration under this section in accordance with this agreement, the emboldened words can readily be interpreted as a reference to the procedural restrictions on submitting a claim. Now, my lords, my lady, we do not just rest our case on Article 11.1.1 and the ordinary meaning of those words. We also rest our case on 11.17 and the express agreement to consent to arbitration in accordance with this agreement. Now that really matters, because what I showed you yesterday and what my learned friend has been unable to respond to is that there are many factors that condition the existence of the consent to arbitrate that are contained outside of Section B. I'm just asking you to interpret 11.17 in accordance with the ordinary meaning of the words. The agreement does not mean this section, and as I said yesterday, if this was just a repetition of this section, then the words in accordance with this agreement would be deprived of any useful effect, which is contrary to a basic rule of treaty interpretation. Now, the court has already seen, if we go to the FTA, how certain provisions outside Section B unquestionably go to the existence of the agreement to arbitrate. Now, I took you yesterday to 11.14, which is bottom of 270, the denial of benefits provision.
11.11.
Sorry, I do apologise, my lord. 11.11, denial of benefits.
11.14, subrogation.
My lord, I will obviously be coming back to that and just making the same point. Because 11.11, plainly the arbitral tribunal, in order to assess its jurisdiction, will have to see whether there has been a denial of the benefits of this chapter. My learned friend had no answer to that point other than to take you to two strictly irrelevant cases concerning the equivalent denial of benefits provision in the Energy Charter Treaty, which talk about denying the benefits of this part. And that denial of benefits provision is within the part of the Energy Charter Treaty which deals only with substantive protections. Here, the words "this chapter" are used, and that, on its natural meaning, comprises the entirety of the chapter. That is why we took you, in our skeleton argument, to cases which deal with the equivalent wording, i.e., which refer to this chapter, and where tribunals have consistently held that where there is a denial of benefits with respect to this chapter, that encompasses the agreement to arbitrate. So if I could take you to an example of that, the Pack Rim case, and my lords, my lady, that is at volume 1 of the authorities, at tab 15. So this is a decision specifically, as you can see, on jurisdictional objections, a panel chaired by Mr Vida QC. And if I can ask you to turn to the denial of benefits at 1452, paragraph 4.1, this third issue regarding denial of benefits arises under CAFTA Article 10.12.2, which permits but does not require a party, a CAFTA party, subject to Articles 18.3 and 24, to deny the benefits of Chapter 10 of CAFTA. And I can confirm to you, my lords, my lady, that the words in CAFTA are this chapter. They've simply put Chapter 10 of the CAFTA in square brackets to convey that point to an investor of another party that is an enterprise of such other party into investments of that investor if the enterprise has no substantial business activities in the territory of the party. And if I can ask you to have a finger there before I take you to the reasoning, and also to have a brief look at Article 11.11 2 of the chorus FTA and you can see that it is substantially identical wording. Then if I could ask you to read 4.2, 4.3 and 4.4, not just making the point that this goes to the denial of benefits, including the benefit to arbitrate, which certainly answering my Lord Phillips's question, it's an essentially important benefit for an investor, but also expressly distinguishing the more limited issue under Article 17.1 of the Energy Charter. And if I could ask you also to read the decision, obviously there's a long passage of reasoning which we haven't troubled the court with, at least in the hard copy of the authorities. Decision at 4.92. Respondent has established under CAFTA to the required standard and burden of proof as a matter of fact and international law that the claimant as an investor and its investments in El Salvador can receive no benefits from Part 10 of CAFTA upon which the claimant's claims necessarily depend, and accordingly that the centre, ICSID, and this tribunal can have no jurisdiction or other competence in respect of any such CAFTA claims. Let me say this decision doesn't reflect their non-CAFTA claims. But so rejecting, for want of jurisdiction, on the denial of benefits issue. You can see that overleaf at 7.1, again at 7.1A3, rejecting jurisdiction by reference to the denial of benefits issue. Now we submit that is exactly what one would expect because of the use of the words this chapter, and because on its natural meaning the benefit of international arbitration is a benefit. It's a very significant benefit, in fact.
So the tribunal held no jurisdiction under CAFTA, but there was jurisdiction under the investment law.
Yes, my lord, that'd be a domestic investment law, which had no denial of benefits.
And what was, and the point on the point is to the application of Article 10.12.2. Was that disputed by the claimant?
Yes, I do believe it was, my lord, because their point was to rely on the Energy Charter treaty type case where different decisions had been reached by reference to different language.
So we've got the respondent's case at 4.6, but then we don't have anything after that.
That is simply perhaps in a mistaken attempt at assisting the court by not having lengthy extracts, but in the hard copy, sorry, in the soft copy on the PDF, the reasoning will be there and you will be able to see the claimant's position. Maybe that Mr Webster can help me right now by giving you the reference to that. its only response to our reliance on Pac Rim and also to the other cases in our skeleton at, I believe, footnote 9 was simply to ignore them. You can see that at tab 3 of the core bundle, page 27, and you can see that at 32 and footnote 9. So the point, there are 2 points. One, this is an example of where the treaty parties say this chapter, and it means this chapter, same as Article 11.1.1, but also when the consent of the chorus parties to arbitrate is expressly in accordance with this agreement, that cannot mean section B alone, as the judge said, because the tribunal has to look outside to see 11.11.
And you say 11.14.
Precisely the same point, my lord, so far as concerns 11.14, which again, my learned friend has no answer at all. Of course, it's going to be a case
Well, I think he said, did he not, that the subrogated party can't claim it. Doesn't have an arbitration right.
Well, but with respect, and I think my lord has perhaps put this to him in a question, how does that make sense? A is a matter of natural reading, but B, so far as concerns the final words of 11.14.1, and the investor shall be precluded from pursuing such rights to the extent of the subrogation. So where then is the investor's right to arbitrate when there has been a subrogation?
I think it was suggested that maybe the subrogated party would bring the claim in the name of the claimant.
That, my lord, that is not what 11.14.1 suggests in any way, is it? In fact, that is going directly against the express words of 11.14.1. So again, we make 2 points. In 11.14, this chapter means this chapter. And plainly, when you come to 11.17, this agreement means more than section B, as the judge expressly concluded. And we do, with respect, say here that his reasoning was completely erroneous.
Why is it 11.17 so important? Suppose it wasn't there. Wouldn't you still be saying that consent to arbitration is only on terms set out in the agreement, which is the agreement as a whole?
My lord, that I would say is problematic for 2 reasons. Because where do you get the consent to arbitrate from? So 11.16, it says in broad terms, you, claimant, may submit a claim. That's saying you can do something. But then you absolutely have to have consent to arbitrate. So you have to have the other side of the coin. But not only that, my lord, again, you have to give meaning to the words of 11.17. And that applies with respect to the provision as a whole and with respect to in accordance with this agreement. I'm just reminded by Mr Webster how how Elliott sought to respond to our point on the denial of benefits provision in its skeleton, and oh no, oh sorry, oh sorry, I do apologise, my lord. What Mr Webster has done is to give the references to the claimant's subs in the Packrim case.
Yes.
Which start at paragraph 431, which is page 1461 of the bundle, and you could see in particular 4.49 at page 1466. So certainly that this was a contested issue. I don't know, my friend was taking me back to a passage in their skeleton where they're not in a position to say anything against the Packrim case and the other cases that we refer to in our skeleton. And that is there also, but I don't think it's worth pausing on to look for it this very second. My lord, my lords, my ladies, so 1117, the words "this agreement" mean what they say. They say, in effect, that the tribunal is having to look at, amongst other things, 11.11 and 11.14. But in fact, the tribunal is going to have to look at other provisions. Of course, we say 11.1.1 in order to assess its jurisdiction. But, my lady, I think this is in response to a point that you were raising yesterday as to the point about temporal application. So if I can ask you to look at 11.1.2, and you'll see the point there being made by reference to this chapter, again we say must mean this chapter, does not bind either party in relation to any act or fact that took place or any situation that ceased to exist before the date of entry into force of this agreement. Now, the point I was making yesterday, which my learned friend had no comeback on, was that that must go to both the substantive protections and the protections of Section B. And the point I would like to make, or to emphasise, is that you do not find that temporal application within 1116. So again, this is an example where the 2 points apply. This chapter means this chapter, and this agreement means this agreement. The arbitral tribunal, in order to identify its jurisdiction, here with respect to events that have ceased before entry into force of the treaty, they have to look outside Section B. My lady, my lords, my lady, another point which comes out of here, specifically out of 11.1.1, is that the chapter applies to measures adopted or maintained by a party relating to not just investors of the other party, but also the covered investment. So that is not, again, that is plainly a jurisdictional criterion. I think both parties before you are agreed on that point. That is not a jurisdictional criterion that comes out of 1116 or the definitions in section C. So if I can remind you what the definition is of covered investment, and that's at page 120 of the core.
Doesn't that then refer to 1128?
My lord, it does refer to it, but I think it's very important to identify how it refers to it. Covered investment means, with respect to a party, an investment as defined in Article 1128, but then there are two criteria, both of which you do not find in the definitions. One, that is in existence as of the date of entry into force of this agreement. Sorry, that was two. I do apologise. One, in its territory of an investor of the other party. And two, in existence as of the date of entry into force of this agreement, or established, acquired, or expanded thereafter. So you see there are two specific conditions being added to the 11.28 definition of investment. So if I can ask you then to go forward in the bundle to the definitions at 285, you see that investment means every asset. You see that as a very broad definition indeed. You already have that point. Then the judge relied on at 287, investor of a party means a party or state enterprise thereof, or a national or an enterprise of a party that attempts to make, is making, or has made an investment in the territory of the other party. So you see, that is in fact different to the definition of covered investment. Because this would cover an investment made at any time, unlike by reference to the covered investment, which requires that existence be there at the date of entry into force of the agreement. But it also allows for the situation where, as an investor of a party, you could say, well, I have an investment in the territory of the other party, so I qualify as an investor of a party, but in actual fact, the investment claim I'm bringing concerns a different form of investment, i.e. an investment outside the territory of the party. Because the territorial limitation is not within the definition of investment.
Okay, so you're saying you can be an investor of a party if you happen to have an investment in the other state, and then
My lady.
as a jurisdictional matter.
Exactly. That's not a fanciful point. Like I sense that you might think it is. But if you think of two of the cases that you've been taken to, the Bayview case and the Canadian Cattlemen case, they both concerned cases where you have an investor who is seeking to bring an investment in circumstances where the relevant investment is in its own state. So, for example, in Bayview, it's the US investor is unable to show a relevant investment in Mexico. It's a case about the transit of water from Mexico into Texas. And Canadian Cattlemen, it's rather similar in a way. It's about impacts of a US measure on the investment of the Canadian investor in Canada. I'm not saying that the US wording of NAFTA is identical here. I made the point yesterday that it was not. Because the definition in NAFTA of investor of a party does include does not include a territorial limitation. But that would not be an answer if on the Bayview facts, or if on the Canadian Cattlemen facts, the investor did have some form of an investment in the other state. So, while we take issue with the judge's reference to any criterion of a need to have jurisdictional fibre within Article 11.1.1, sorry, I put that another way. The point he made is once you find some jurisdictional fibre in 11.16, then there's no need to look elsewhere. And we say that is wrong as a matter of principle. You have to be reading the treaty. In this case, you have to look at 11.16 in context, including 11.17. And, most naturally, you start your reading of the chapter with 11.1.1, which tells you what the chapter applies to. But it is not just that there is plainly jurisdictional fibre, if that were the test, within 11.1.1. It is jurisdictional fibre that is not to be found in 11.16. That also applies so far as concerns 11.1.2 on the temporal limitation.
Is it right that on the temporal limitation that you don't get the limitation from Article 11.1.2, that there would be no temporal limitation on a breach of an investment agreement?
So, in an investment agreement, you'll see, and this I think is a point against Elliott, an investment agreement, if you look at both the proviso for 11.16 and to the definition, there is a requirement that there be a covered investment.
But a covered investment can be one in existence at the time the treaty is entered.
My guess.
I think the point I'm making is it's in your favour if if I'm right about it, if I understood it correctly, is but for 11.1.2, a breach of the investment agreement could refer to a breach before the treaty is entered into.
Ah, my lord, yes, I see that.
Is that right?
That. And not only that, but also with respect to the jurisdiction under the 11.16(1)(a, that the respondent has breached an obligation under Section A.
But that can only be after the treaty's come into force.
But on what basis? Without 11.1.1? Sorry, 11.1.2.
Well, because the obligations would only come into effect.
My lord, yes.
And I think the point is less strong in relation to Section A obligations if you take the approach that is being argued against you, that effectively those provisions do qualify Section A.
Yes.
The point seems strong in relation to investment.
Yes.
I think that the point is that on Elliott's case, an investment agreement is not qualified by the brief.
Yes.
Claim under C is not qualified,
Yes.
and therefore theoretically it could relate to breaches from years ago,
Yes.
before the treaty.
Yes, my lord, I apologise.
No, just trying to understand.
Yes. But perhaps I could make a different, but in a sense a related point, by reference to 11.16 as a whole, or 11.16.1 as a whole, because as I understand Elliott's case, it accepts that the reference in 11A1B to the existence of the investment authorisation as subsequently defined goes to jurisdiction. And I also understand it to be accepting, or to be its positive case, that the existence of the investment agreement as defined goes to jurisdiction. So if that is right, then suddenly why is A an exception? So why, consistent indeed with Article 11.1.1 and Article 11.17, that also be a jurisdictional question? Now, going back to 264, the wording of Article 11.1.1, this chapter applies to measures adopted or maintained by a party. My learned friend said this morning that in order to decide whether there was a measure or not, you would need to decide whether there was an expropriation, and therefore you would be going straight into the merits. But that is plainly incorrect. In order to decide whether the measure is, there is a measure or not, you just apply the definition of measure, which, my lords, my lady, you've already seen at page 122. And you see it includes any law, regulation, procedure, requirement, or practice. So is there such a law, regulation, etc.? in order to decide that issue, you don't have to decide issues of merits. The issue
Well, you look at what's alleged and decide whether that is a measure,
well,
or do you?
you have to decide whether it is a measure or not. So you have to decide, as a fact, is this something which is a law, regulation, act, or practice? You have to decide
presumably,
that jurisdictional matter.
Presumably to decide ultimately, you have to decide what happened, don't you? Because you can't decide whether what happened was a measure until you determine what happened.
No. With respect, no, my lord, because you're saying, did the state do something? It's as simple as that. So did the state pass an act? Did the state adopt some regulation? That's all you're doing. Yes, no. The question of breach then, for example, on expropriation, then you would have to turn page 266 to Article 11.6. Neither party may expropriate or nationalise a covered investment, either directly or indirectly, through measures. And the question there is a very different one. Is there an expropriatory act by reference to the measure? That's the issue of the merits. And in deciding the question of is there some act by the state, has it passed an act or whatever it might be, that's just a very straightforward, or maybe depending a little bit on whether it has to be a formal form of act or not, but it's just a straightforward factual exercise. It doesn't take you into the merits.
Well, it's at least theoretically the case, isn't it, that you can't decide whether or not an expropriation was an act of the state until you have determined what was done by way of expropriation.
Well, no, I think not, my lord, because the question is, one, did the state do anything at all? Now, of course, again, as subject to our specific case on what does it do anything at all mean.
Well, who did what and under what authority may be the question.
Well, who did what is a question of measure, i.e. did somebody do something. The question of under what authority is a different issue, because that comes in under the question of 11.11, whether the chapter applies to a measure adopted or maintained by a party. So you have to say, did a party do this act? And then you are told who the relevant party can be by reference to 11.1.3. So these, we say, these are jurisdictional criteria which you have to run through in order, consistent with 11.17, consistent with the ordinary meaning of the words, before you get the substantive obligations, the substantive questions of breach. My lords, my lady, that takes me to the next point I wanted to deal with, which is about the supposed inconsistencies between Article 11.1.1 and the definition that you get of, or the proviso that you get in 11.16 with respect to the investment agreement. So that there are 2 points being made against me. One is that it's measures adopted or maintained by a party, which has a broader definition than just a central authority. And two, that the word relating to, or the term relating to, is different to what one sees in the proviso, which is one of direct relation. And you'll recall from the definition of an investment agreement, has to be an agreement with a central authority of a party. Now that is not dealing with our point of principle at all. Our point of principle is that in order to get to this exceptional treaty protection, it is entirely unsurprising that you would have to apply specific treaty criteria. That is what you'd expect to see. Because as I said yesterday, the investment agreement in the usual course is going to be, will contain its own dispute settlement mechanism. So no surprise at all that you have to go through the treaty criteria in order to get to this exceptional recourse to treaty arbitration. So there's no answer to that at all from my learned friend. He says a point on inconsistency, but again, there isn't a material inconsistency here. All you see with respect to the investment agreement is narrower criteria when you come to this specific form of arbitration under Section B. So you already have to deal with the jurisdictional criteria of measure adopted or maintained by a party relating to. If you get through those criteria, well, there are some additional criteria to meet in the specific case of the investment agreement. That's not a meaningful inconsistency. My lords, my lady, in the limited, I say I've only got 15 minutes left, and I'd like to deal with the issues on Article 32 and on the diplomatic note. The first point being made on Article 32 is that I was making a different point in front of Mr Justice Foxton as I've been making before you. I'd say that's a point of very little moment indeed, partly because the judge in his questioning was focusing on travaux and circumstances of conclusion, partly because at that juncture I was not focused myself on the 2018 ILC draft conclusions, which refer specifically to the ability to take subsequent practice into account under Article 32, and partly also, of course, because I was not focused there on the issue of subsequent practice of NAFTA parties or the parties to chorus at all. I was focusing on the issue of the awards. I should also point out that this is a matter that we raised in our skeleton argument and the judge himself was aware that the issue of Article 32 had not been fully argued before him, and therefore he made a specific point about this. You can see that at page 37, tab 3, at footnote 16, Career acknowledges that the points relied upon in respect of the Article 32 arguments are broader than before the judge. However, the Article 32 point was raised by the judge and he imposed a very tight timescale for addressing it, written submissions by 6 p.m. on the first day of the hearing. The judge stated during the hearing that in proceeding this way, the Article 32 point would be live on the appeal, and if further material of a legal kind at least comes to light, no doubt it can be deployed in that context. So we say absolutely. We're not focusing at that stage on the ILC draft conclusions. My learned friend tries to belittle those, but they say in terms, in one of the conclusions itself, that you can take into account subsequent practice of one party. The point, there's a temporal point being taken against me, which says you have to stop the clock when the treaty is signed, and you shouldn't be looking beyond that point in time. Now, obviously, the subsequent practice issue is a separate one, but my learned friend said that there were no negotiations between the signature and coming into effect in 2012 of the treaty. Now, that's simply wrong, as a matter of fact. And if I can give you the reference to that, you can see that at 71, tab 71, 5202. And in fact, there were negotiations. You can see there was an exchange of legal text reflecting an agreement in 2010, and that was an exchange of legal text reflecting an agreement concluded on December 23, 2010 to set the stage for congressional consideration of chorus. So plainly there were negotiations prior to entry into force. Reliance being placed, of course, on JTI Polska, but we do say that the material, again, it's very different in nature to that before the Supreme Court in JTI Polska. Point is continually being taken against me that somehow arbitral awards are just like expert reports, and so there's a close analogy there. Well, we say not only is that incorrect, but in any event, we are relying on a consistent practice so far as concerns the NAFTA states, dealing with substantially identical wording of Article 11.011 since the year 2000. So different in nature to the material before the court. And not only that, one can see how the wording of Article 11.011 NAFTA fed into the model US BIT, fed into the chorus FTA, and that's part of the reason why the NAFTA material is so relevant, or is genuinely relevant in this case. And of course, the decision as to the meaning of Article 11.11 which is, as I say, and I don't believe was challenged, is substantially identical to 11011, it has real importance for not just the US, not just Korea, but all those who are party to the model BIT, i.e. concluded treaties on the basis of the model BIT, and other US FTAs which use the identical wording as 11.1.1.
The difference I've got with this is that although the answer to this question may give rise to a serious issue, the two answers are complete dichotomies. One of you is right and one of you is wrong at the end of the day, as a matter of interpretation.
Yes, my lord, yes.
Either Article 1.1 conditions the jurisdiction for the arbitration, or it doesn't.
Yes.
And that was the position when the treaty was signed.
Yes.
So if thereafter one or other of the contracting parties misunderstood which of those two constructions were right, can their misunderstanding be converted into the correct interpretation by virtue they consistently misunderstood it? I mean, how does it work? How can their misunderstanding, if that's what it is, affect its interpretation?
Because you're looking at a misunderstanding that forms the basis of the wording in the first place, and that feeds through beyond the conclusion of this treaty and its entry into force, including beyond entry into force. So
I can see if it was a subtle difference, and the position might be something that you might be persuaded to change from one to the other, but this is a complete dichotomy which completely changes the jurisdiction over arbitration. And so I can quite see when you're looking at that interpretation, the position that had been adopted beforehand would be factored into deciding what that interpretation is at the date the treaty is entered into. But the idea that you reach an interpretation as at the date the treaty is entered into, but that can be changed dramatically from Elliott to Korea because subsequently the US and Korea have misunderstood the interpretations. I just don't see how that works.
Well, my lord, perhaps I can put it this way. So on our case, you have the treaty entered into by reference to an already understood meaning of these words.
That I see.
And then the subsequent practice, we say obviously it comes in under 31(3)(c), but even as supplementary means, all we're doing is asking you to use that as confirmation.
But either it was enough at the date of the treaty or it wasn't. If it wasn't enough at the date of the treaty, you can confirm it as much as you like, can't you? Because it's still a mistaken interpretation.
My lord, I don't think I've got any better answer than the way I've tried to put it, which is to look at all the material that goes to supplementary means in the round, and the subsequent practice at the very least is confirming that there was a well-established pre-existing meaning at the time of entry into force of the treaty.
Can I ask you one other question? I know you haven't got very long, but in relation to looking at NAFTA and the approach to it in interpreting chorus, it seems to me if you were in a world where you just looked at the similarity in the language, that might well be, I could see you could use it as an aid to interpretation. But where you're in a Vienna Convention world, where you don't just look at the language, but you look at all the other matters in Article 31 and in 32, how can you read across from one treaty to another when there are all these different factors which go into the interpretation of each treaty, particularly where the language is not the same?
I absolutely see the point, my lord, and that's why I took you to that passage yesterday where you saw that the ICJ itself has looked at equivalent wording in equivalent treaties effectively. It must be as a means of a supplementary means under Article 32. And this is we do submit, this is a unique situation so far as concerns the established meaning of Article 1101(1) NAFTA, and then the feed through. You obviously have my points on that. I have very little time left, and I have to deal very briefly with. I think I probably only have time to deal with the. Well, I thought I only had time to deal with the Ladd and Marshall issue. I just want to emphasise two other points. One is that we say, so far as concerns specifically chorus, there is relevant subsequent practice so far as concerns the US position in the Mason case as a non-disputing party, and the consistent position of Korea, which indeed predates the existence of this dispute so far as concerns the CO and Korea case, but also so far as concerns Mason and this case. So it's consistently taking an approach to the meaning of Article 11.1.1. And I also want to refresh your mind about the expedited mechanism that I referred to yesterday, Article 11.20, which you could see from the US submission in the CO case, was expressly introduced by reference to a discomfiture with how long Methanex took to decide the issue. That shows you how NAFTA, taking into account NAFTA interpretation, influenced both the model BIT and the FTAs, and that was adding additional protection to the states so far as concerns challenges to both merits and jurisdiction. And we say it would be inconceivable if at the same time through the addition of 1116 1A, B and C, the court was the parties were in fact removing a jurisdictional hurdle. Can I make some very quick points about Ladd and Marshall? First of all, to remind the court of paragraph 33 of our application skeleton, where at page 15 of tab 1 of the application bundle, we are taking the point that Ladd and Marshall is not dispositive in every case. The White Book notes, for example, they are less strictly applied in cases concerning children, but they are not dispositive in cases where a public interest is engaged. And if I could ask you in due course to look at Muscat and the Health Professional Council case. Now, we say that Salem, where they are looking at that and Marshall, but also alongside international law principles, insofar as that were the correct approach, and you already have my submissions that this comes down to good faith interpretation, as opposed to some concept of a critical date, which one doesn't see referred to in the ILC draft conclusions at all. We say paragraph 108 of Salem is strongly in our favour, because our position, of course, is that the position being taken by the US in the exchange of notes is confirmatory of the US position, obviously by reference to NAFTA, but including by reference to the chorus. So we say it is confirmatory, and yes, a point is made about the contents of the diplomatic note, and it said, well, hang on a sec, there's some real novelty here, but the diplomatic note was made by the US in circumstances where Mr Justice Foxton had for the first time raised an issue as to the impact of 11.16 1A, B and C. So that is why one sees that point being dealt with. It hadn't been dealt with before. And we say that if there is an issue of whether it was reasonable or not for the note to have been produced before the hearing before Mr Justice Foxton, until that hearing, nobody had ever raised this issue. Elliott did not raise the issue on the importance of 11.16 1B and C, which the judge regarded as highly significant. It was a completely new issue raised by the judge on around about 12 o'clock on the day of the hearing. So we don't accept there is material novelty here. We don't accept there's any modification of prior positions or that there's any unfairness to Elliott, because all that is happening here is the established wording of NAFTA, and we say in relation as that there's relevant subsequent practice on chorus FTA is now being reflected in a diplomatic note. I do see your point, my lord. You suggest it's invidious for the US to be intervening, but we would say when a fresh point is arising, it's natural and appropriate that a state would want to have its voice heard. And it is not as if this US position is targeted at this particular case. We know at the moment it's being considered actively by the Curial Court in Singapore. It's now public. As I told you yesterday, I understand it's going to be made, put on the relevant Korean websites. I see I'm running out of time, or I've overstayed my welcome. But my lord, with that final last point, I conclude our submissions.
Thank you very much, Mr. Wordsworth. Thank you all for your helpful submissions, both those who were in a speaking role and those who were in a drafting and supporting role. We will, of course, reserve judgment. We will send out a draft to counsel in the usual way. As counsel well know, the purpose of the draft is not to invite re-argument of the case, but simply to invite correction of any obvious factual errors, typos and the like. The other thing about the draft is that its contents are confidential to parties and their legal advisors until formal hand down by publication on the National Archive and other public websites. Any dispute as to the form of order, or as to costs, or as to permission to appeal, anything else of that kind, should be the subject of written submissions, ideally agreed as to the form of order, but if not, competing brief submissions setting out points of difference. I think that covers everything. Very grateful for your assistance.
All right.